fortunate to have Arizona Attorney General Mark Baranovich is here with us now. So you just got the decision. This was all about what happened in your state. Let's get your reaction.
Dana, we're very pleased with the result. Thank you very much for having me on. It's not often that a case is not only named after you, but I got to argue that case at the U.S. Supreme Court, and we felt very confident going in that we were right, because the reality is that we want to make sure we do everything we can to make sure every person that's eligible to vote can vote. But we also want to make sure that there's integrity in the process and that people have confidence in the results. And, Shannon was just talking about out-of-precinct voting. A majority of states have the similar laws, and even the District of Columbia. We know that a lot of states have limits on ballot harvesting, and no less than Jimmy Carter said that ballot harvesting was one of the greatest threats to election integrity. So this shouldn't be an ideological issue. This is all about protecting the integrity of elections and making sure that states have the ability to conduct the time, place, and manner of their elections the way they want.
And I'm curious, Attorney General, when you talk about these states, we have done these stories so many times about ballot harvesting problems, and Republicans in a lot of states that are controlled by Democrats have the same concerns. Does this give them a leg up in some of these blue states to be able to take these matters to court as well?
Well, here's the deal. Part of the test that we argued at the U.S. Supreme Court was that if you have any sort of law, and even like the DOJ's lawsuit now against Georgia, first of all, it has to have a substantial impact, and that the law itself causes that impact and diminished voting for minority groups. And so, everyone's entitled to their own opinions, but not their own facts. We have to deal in reality, and every jurisdiction is different. What happens in Manhattan, Kansas is different than Manhattan, New York. What happens in Virginia Beach is different than Redondo Beach. And so we have to, under our system of federalism, the states are allowed to enact common sense election integrity measures. It's as simple as that. And what we've seen from the left, even with H.R. 1 and S1, is an attempt to nationalize elections and concentrate power in Washington, D.C. And that is to favor the far left. And I'm a first-generation American. I believe very strongly in the Constitution. And the Constitution created a system of 50 laboratories of democracies. The states created the federal government. And it's not up to, Chuck or Nancy or anyone else in Washington, D.C. to tell Arizona or anyone else how they should conduct an election.
I had a question about the fact that, you had been there to argue the case, and I know that obviously is a huge honor for you, and I'm sure your family was very proud as well. And then to win. What did you think about that day? Did you anticipate that you would win? Were there questions that the justices asked that led you to believe that this would be the result?
Dana, honestly, I am so humbled. I think about the fact that, I said my family fled communism. I'm a first-generation American. And to me, be the chief law enforcement officer and argue the U.S. Supreme Court, we don't have a national religion. We don't have a common ethnic identity. I think someone like me, that people can't even spell my name, to be arguing at our court, making case law that, my kids or somebody else may read about in the future is really humbling. But we felt confident. We felt that if we argued the law, we stuck to the Constitution, we were going to win. And so often now, these issues related to voting have become so highly partisan and highly political, and they shouldn't be. And, and I know during the argument, we had put in our briefs, and Justice Roberts actually alluded to Jimmy Carter warning about ballot harvesting and mail-in ballots. And so I thought that was a great sign that Justice Roberts was aware that there was a time when even Democrats were in favor of election integrity.
Can I ask you then one other thing? I know that you can't look into the future too much, but because the Democrats are determined to try to pass S1, as you said, that big election bill, or now the John Lewis Act is coming forward, it has similar things, would either of those laws, if they were to pass, right now there's not the votes, but let's say that they passed, given this decision that we just see today, would those laws actually hold up in the Supreme Court under this decision?
John Lewis was an amazing human being, and shame on the Democrats for trying to use his legacy to, tar or, do anything to undermine voter integrity, because there are a lot of people like John Lewis. And even here in Arizona, there was testimony during the trial from African-American leaders here in Phoenix that said there were people going around saying they were government officials, and they were worried about ballot harvesting, and they were worried that impact it would have on the African-American communities. So the problem, I think, Dana, in this country is that we cannot and we shouldn't always rely on Washington, D.C. solving our problems. I do think that if H.R. 1 or S1 tries to pass, I do think there are serious constitutional questions about it. I do think it's constitutionally suspect. So it's not only a bad idea, I think it is unconstitutional.
Attorney General, congratulations to you, and thank you for being here with us today. And we'll go back to Shannon Bream now. Shannon, you have another opinion you could add to us?
We do. This is the final one. This is that California law that was going to require charitable organizations to turn over their donor lists and names. Many of them are political groups, or think about giving to a group that you think is maybe not in the most popular part of pop culture right now. So this was an interesting case because it brought together groups like the ACLU and the Heritage Foundation on the left and the right, saying, no, we don't think that groups should be forced to give up the names of people who have donated to these political causes or groups. 6-3. Again, the conservative and liberal wings at odds with each other here, saying that California law cannot stand. There are all kinds of fractured additional concurrences and kinds of things that, you understand that there are. Everybody wanted a piece of writing something about this. But here's a bit from the opinion, the majority opinion. It says, when it comes to the freedom of association, the protection of the First Amendment are triggered not only by actual restrictions on an individual's ability to join with others to further shared goals. The risk of a chilling effect on association is enough. And that had been the argument. People don't want their name out there. They may stop engaging in political causes. They may stop donating to things that they personally feel connected to if they're worried it will be used later to dox them or to shame them. And the court was clearly very worried about that chilling effect. So the California law requiring donors' names to be turned over has been struck down. We'll continue reading through it, but the dissent looks like it's authored by